Hello everyone, welcome back to MAYANK LAWHOLIC. In this video, we will be pursuing the MCQs of jurisprudence. This is the 8th video of the series, and if you want to watch the other videos also, please find the link in the description section. And also, it is a humble request, please subscribe us. Now let us proceed from question number 176. Give correct response. Option A, the obiter dictum has binding force. Option B, ratio decidendi has binding force. Option C, ratio decidendi and obiter dictum both have binding force. And option D, neither ratio decidendi nor obiter dictum has binding force. Here in this question, correct answer is option B, that is ratio decidendi has binding force. Now let us proceed to question number 177. Which one of the following is incorrect meaning of ratio decidendi? Option A, reason for decision. Option B, all principles of law laid down in the decision. Option C, preferred rule of law by judge on which decision is based. And option D, rule of law which others regards as binding. Here in question number 177, correct answer is option B, that is all principles of law laid down in the decision is the incorrect meaning of ratio decidendi, whereas reason for decision, preferred rule of law by judge on which the decision is based, and rule of law which others regard as binding are the correct meaning of ratio decidendi. Question number 178. Which one of the following is regarded as unnecessary for a custom to be valid custom under the Indian legal system? Option A, antiquity. Option B, recognition by the courts. Option C, reasonableness. And option D, continuity. Here in question number 178, correct answer is option B, that is recognition by the courts is regarded as an unnecessary for a custom to be a valid custom under the Indian legal system. Now let us proceed to question number 179. The importance of custom over the other sources of law was stressed by the jurists of the analytical school, historical school, natural law school, none of the above. Here in question number 179, correct answer is option B, that is historical school. Question number 180. Custom precedes legislation, hence in superior to it, and a legislation must conform to the principles of custom. This principle is a basic feature of which school? Option A, sociological school. Option B, historical school. Option C, analytical school. And option D, natural law school. Here correct answer obviously is the historical school of jurisprudence. Question number 181. Custom is to society what law is to the state. It has been said by option A, Dice. Option B, Salmon. Option C, Lloyd. And option D, Finch. Here in question number 181, correct answer is option B, that is Salmon. Question number 182. The growth of custom into law is analogous to the growth of law itself in an infant society. Who said it? Allen, Savigny, Magby, Selman. Here in question number 182, correct answer is option B, that is Savigny. Question number 183. Which one of the following is an essential element of a valid custom? Option A, continuity. Option B, consistency. Option C, certainty. And option D, all of the above. Here correct answer is option D, that is all of the above. Question number 184. Which one of the following is not an essential element of a custom? Option A, certainty. Option B, reasonableness. Option C, continuance. And option D, moral force. Here correct answer is option D. Moral force is not an essential element of a custom. Question number 185. Which one of the following is not an essential element of a custom? Option A, a custom must be certain. Option B, a custom must be reasonable. Option C, a custom may not have been practiced continuously. And option D, a custom be in conformity with the statute law. Here in this question it has been asked which of the following is not an essential element of a custom. Thereby the correct answer is option C. A custom may not have been practiced continuously is not an essential element of a custom, whereas a custom must be certain, a custom must be reasonable, and a custom must be in conformity with the statute law are the essential elements of custom. Question number 186. Which one of the following is not an essential element of a valid custom? Antiquity, continuity, uncertainty, peaceful enjoyment. Here in question number 186, correct answer is option C, that is uncertainty is not an essential element of a valid custom. Question number 187. Which one of the following is not an essential element of custom? Option A, antiquity. Option B, certainty. Option C, peaceful enjoyment. And option D, inconsistency. Here in question number 187, correct answer is option D, that is inconsistency, and inconsistency is not an essential element of custom. Question number 188. The following jurist does not support the theory of that judge make law. Hart, Holmes, Gray, Dworkin. Here in question number 188, correct answer is option D, that is Dworkin does not support the theory that judges make law. Question number 189. The constitutional basis of the doctrine precedent is contained in the following article? Option A, Article 136, option B, Article 141, option C, Article 226, and option D, Article 227. Here in question number 189, correct answer is option B, that is Article 141. Question number 190. Which statement of the following is correct answer with regard to a decision given by per incuriam? Option A, decision is binding, option B, decision is illegal, option C, decision is unconstitutional, and decision option D, decision is not binding. In question number 190, correct answer is option D, that is decision is not binding. Question number 191. I think adherence to the precedent should be the rule and not the exception. This has been said by option A, Cardozo, option B, Blackstone, option C, Keaton, and option D, Thebault. Here in question number 191, correct answer is option A, that is Cardozo. Cardozo has said that I think adherence to the precedent should be the rule and not the exception. Now let us proceed to question number 192. Dealing with the sources of law, who amongst the following was said that the courts fuel life into dead words of statute? Option A, Holland, option B, Gray, option C, Salmon, and option D, Austin. Here correct answer is option B, that is Gray. Gray said that the courts fuel life into the dead words of statute. Question number 193. Who one is the main propounder of declaratory theory of judicial precedent? Option A, Blackstone, option B, Gray, option C, Salmon, and option D, Dicey. Here in question number 193, correct answer is option A, that is Blackstone. Question number 194. Law is what the judges declares. This statement relates to which of the following thinkers? Option A, Jerome Frank, option B, Julius Stone, option C, Gray, and option D, Holmes. Here in question number 194, correct answer is option C, that is Gray. Question number 195. Subordinate legislation emanates from option A, any authority other than the sovereign power, option B, dictators to subordinates, option C, usage of immemorial antiquity, option D, any subordinate being. Here in question number 195, correct answer is option A, that is any authority other than the sovereign power. Question number 196. A legislation incapable of being replaced, annulled, or controlled by any other legislative authority is called option A, delegated legislation, option B, subordinate legislation, option C, supreme legislation, and option D, judicial legislation. Here in question number 196, correct answer is option C, that is supreme legislation. Question number 197. Which one of the following is not a means for exercising control over delegated legislation? Option A, parliamentary control, option B, judicial control, option C, publication of delegated legislation, and option D, requirement of registration of delegated legislation. Here in question number 197, correct answer is option D, requirement of registration of delegated legislation is not a means of exercising control over delegated legislation, whereas parliamentary control, judicial control, and publication of delegated legislation are means for exercising control over delegated legislation. Now let us proceed to question number 198. According to Salmon, supreme legislation refers to colonial legislation, executive legislation, judicial legislation, law made by the parliament. Here correct answer is option D, that is law made by the parliament is, according to Salmon, is supreme legislation. Question number 199. Which one of the following is not a safeguard against the delegated legislation? Option A, parliamentary control, option B, judicial control, option C, publication, and option D, public control. Here in question number 199, correct answer is option D, that is public control. Question number 200. Which of the following is not a form of subordinate legislation? Option A, colonial legislation, option B, autonomous legislation, option C, conditional legislation, and option D, judicial legislation. Here correct answer is option C, that is conditional legislation is not a form of subordinate legislation. So here we will sum up this video, and it is a humble request to please like, share, and subscribe. And if you want to watch further videos of the jurisprudence, please follow this series carefully. Now, thank you so much. Thank you for watching. Please like, share, and subscribe.